below the age of 15. I beg to proceed. It is thus on this matter that I invite this honorable court to find this matter as thus at this point that court should take judicial notice of the facts at hand. Your Lordship, we have 500 people that are dying per day. If you multiply that in a year, we have 180 people, 180,000 people dying in a year. Much obliged, my lord. It should be noted, Your Lordships, that the petitioners have stated in their case that the state of Malta is indeed abrogating its duties. However, the state of Malta is trying to do all the measures it has in the best interest of its citizens. And I invite court to take this as a judicial notice, as was stated in the case of C versus R, the Supreme Court ruling in India, where it was stated that the state, where it was stated that court must take judicial notice of the facts, where guidelines are issued under situations wanting security measure. Your Lordships, I beg to respect this, and I need ground for my proposal to submit.
Before you rest, you're going to answer this. You have to persuade this court that show us whether the decrees made by the president of Maltese are acceptable in a free, fair, and democratic society. Just how to this aspect that. Are they free? Are they fair? Are they acceptable in a democratic society?
Much of thank you, Lordship. What has to be taken into consideration? Much of thank you.
Much of that, my lord. My previous honorable court, for purposes of court report, I'm Councilor Shadia, senior attorney under the office of the Attorney General. My lord, I'm dealing with an issue whether or not the directives of the president are in contravention with the constitutional provision of chapter 6, 7, and 8. My lord, this constitutional court is not closed with jurisdiction. Just for simple reason that the provisions given by the petitioners do not disclose which provision needs interpretation. Yet, according to Article 137, the role of the constitutional court is for interpretation of the provision. My lord, I invite you to the case of East Maselko versus KCCA. I beg to read it verbally. Where court held that the constitutional court to have jurisdiction, the petition that the interpretation of a constitution is required, and it is not enough to claim that the constitutional provision has been violated, or if the rights have been violated as claimed under Article 50. So this court does not have jurisdiction to deal with the rights the petitioners are claiming by law that are being violated. But for purposes of academics, I proceed. I beg to proceed. Justify the decree given by my president, my lord.
That is basic, that's What is the value issue?
My lord, I proceed. The petitioners contend that the presidential directives are in contravention of chapter 6, 7, and 8. My lord, I invite you to Article 1999 of the Constitution that gives the president over the Chief Justice, and the Chief Justice is the head of the judiciary, and over the Speaker, and the Speaker is the head of Parliament. This shows that the president takes precedence over the judiciary and the executive and the legislature. My lord, the petition, furthermore, Article 99 vests all executive authority in the president in accordance with the Constitution and any other law. My lord. So, any other law, it also includes the Public Health Act. My lord. So, yes.
Also, Sharon told us permission is not about this, about the president advocating the power of the other branch.
My lord,
We know the president has to the issue of application.
My lord, in this regard, as I still explained, that the president can act either directly or through the subordinate officers, and the subordinate officers also include the minister of health. So that gives the president the powers to issue a decree that protects the citizens of Malta. My lord. And the petitioners were also claiming that suspension of parliamentary sessions and closure of courts is unconstitutional, my lord. But section 29D of the Public Health Act clearly states that all persons that are in areas that are infected are not allowed to move unless they are disinfected. My lord, and this provision does not exclude parliamentary members, my lord. So by them coming together, it's going to split and even increase the spread of the deadly COVID.
Okay, let's go deactivate.
My lord.
Take a video.
So and then this is not the only way they can provide for parliamentary sessions. We are in a developed world.
Yeah,
Technology keeps on evolving. They can do it via Zoom. They can attend parliamentary sessions using that thing.
no.
That's what you are sustaining.
Yeah.
Yes, we
I go
have
back to
suspended physical parliamentary sessions.
Okay. I'm not saying the sources. Yeah, I'm saying that.
Section 28,
Saying
I have to
deactivate.
read it verbally.
What?
The Public Health Act is just
It's not showing on the screen. It's been showing configure video. Configure crossbar.
gives the
Deactivate and not
president
showing.
the authority to make these directives in consultation with the Ministry of Health.
What do you want?
And I also want to show the purpose and effect of the directives of the president. So my lord,
No,
I want to
that
persuade
one.
this
Yeah,
court,
I'm saying it.
inviting them to the case of Superior versus
I'm
Edge.
saying.
I don't read it verbally.
Yeah, I'm saying sources.
Where court held that both the purpose and effect are relevant in
saying it.
determining the reason as to why a certain
I'm saying
provision
it.
or acts are done, my lord. And it is clearly shown by
No.
some people as the spokesperson of government that this was intended
Properties of
to
government.
combat the spread of the deadly COVID virus. My lord, the facts clearly show that all over 3,000 people are affected in a day.
Yeah,
Let's
yeah.
do a simple math. Multiply this times 7. We have like 21,000 people that are infected, my lord. So basing on this,
No, it's even not there.
basing on this clearly shows that if parliamentary sessions are to be allowed, and the courts that they are claiming that are closed are to be open, this sparks of and increases the spread of that deadly COVID. My lord.
Detect HD or OBS version. Version. Okay,
My lord.
still empty.
And to wrap up my submission.
I'm saying that the logo is back, but
My
it's
lord,
empty.
in the claim that there are exposure of courts, we all know it is always
Now we
encouraged
just
that
broke the
desperate
screen
times
with the
have
Moot
called for
code
desperate measures,
20.
my lord. So this is justified by the case of R versus Secretary, where a court held that the Secretary's decision to suspend hearings of Roman pilots without
Now it
giving
has
them a
specified
hearing was
it's
justifiable
HD,
to prevent
webcam,
an
and
immediate break.
OBS.
So by government, by the executive closing courts, it is to
Now it has
combat
two,
this deadly COVID-19
HP,
because
HD
it is
camera
an
and
immediate
OBS
break.
virtual camera.
Basing on that, my lord, I pray that court dismisses this petition because
So, yeah, it's light in green. So I go back to OBS.
Maybe this honorable court, my name is Pastor Timothy, appearing in the defense of government. And when this honorable court is talking the severity of the COVID situation we are facing in Malta, we are having deaths that are just an estimate of 500, but are not conclusive. Which means these deaths may even be more than 500. Obviously, yes, they may be less, but that is
Maybe to use
no-
me check. No,
Yes, so in my opinion,
the device I see is still the same. OBS virtual camera HP webcam.
in relation to the facts, in my well reasoned opinion, might be more than 500 as in relation to the facts as and
I'm still looking
I'm
for it.
surprised and it tickles my mind as to whether the petitioners actually understood the situation we are facing. People are dying,
Stop.
families are
I've stopped.
losing their mothers, children are dying. In the facts, there's a lacuna on the persons that are dying.
Well,
So
whether stop video.
this includes fathers, mothers, persons of responsibility, persons
Same
of
thing,
state,
video settings.
and this petition is
choose
here
video
to
stop,
just
video
demonstrate
settings.
without looking at the severity of the COVID-19 infections that we are facing. I beg to continue with my submissions.
I'm saying
My submission
OBS video
will
camera
address
original
issue
Russian.
on whether the directives are in contravention
Today.
of Article 40 of the Constitution and
Yeah, I'm
issues
saying
in
it.
relation
Yeah.
to the readiness. My lord, Article 40 comports economic rights, and these economic rights include the right to work. The right to work, as
Okay.
stated, is not a non-derogable right in relation to Article 40. I beg this honorable court to address itself to the case of Onyango versus Attorney General, where it was stated that any law that prohibits an act that is enshrined and protected by the Constitution may be justified if this law is within the parameters of Article 43, Clause 2. In relation to the facts, the restriction on people to work without COVID-19 vaccination certificate is not in contravention with public policy and political rights, and thus is in the contemplation of these rights, and therefore warrants the suspension of the right to work. My lord, if I may continue with my submission, Article 23, Clause 1, paragraph B is clear that one's liberty shall be deprived for the purpose of preventing the spread of an infectious disease. This is the circumstances we are facing in Malta. COVID-19 is a very infectious disease,
to an extent that we are facing 3,000 cases on a daily basis. This therefore comes within the attributes of Article 23, Clause 1, Paragraph 3. My Lord, if it may please the court, to take the notice in relation to data in Sahad versus Attorney General, where it was stated that the right to health is an economic and social right, and the state ought to fulfill its obligation and protect its citizens within the ambit of this right. It is within the ambit of the government that we are taking all measures, and the measures that we are taking to promote the right to health and combat COVID-19 virus are the ones that the president has proclaimed, or that the president proclaimed on 10 May 2021. By the, in conformity with Article 40, Clause 1, Paragraph A, the council submitted that the legislation did not make laws for the protection of the workers' rights in the healthy and unhealthy and safe condition. I beg to correct him to address himself to the Occupational Health Act, especially Section 13, that entails that all measures as far as reasonable and practicable for the rights of workers shall be enforced to ensure that they are protected from dangerous aspects. With the test we are facing on a daily basis, it would show that the COVID situation we are facing, my lords, is a dangerous aspect in this regard. I beg the court to take notice in the case of Shelter versus the Water and Power Development Authority, where the Supreme Court held that applied a precautionary principle that suspended the work and the construction of the power plant in a residential area until the risks to health and safety of all the public were dealt with. In this regard, we are also taking these measures to ensure that the risk to health to the persons of Malta that are dying in multitude on a daily basis and they are getting infected with this deadly disease are being contained. This is being done as we see in the facts that we are ensuring door-to-door vaccinations to help ensure and protect the people from the risks of this COVID-19. The petitioners are ignoring the populace of persons that are dying and the risk that it entails to the people in their families. I beg this honorable court to take a scenario where one person is going to work, is going to come back to their family, infect their children, infect their spouses, infect their brothers, their sisters, infect all the people in the family, who will subsequently, if given opportunity to work without vaccination, will also go and infect other people, and it would be unwarranted death in Malta when these people are spreading this infectious disease like this. My lord, it would only be practicable that the person's COVID-19 certificates are allowed to go and work because the risk is contained. They are known with their certificates that they are free from this vaccine, and it is also known that they are not at the risk of either spreading or contracting this virus. Therefore, it is only practicable for them to rely on the 1,000 euros that are given by the government to help them go through the scenario of COVID-19. That is enshrined in lines 28 and 29 of the vaccine issue. My lord, it would be a signature to a death certificate if these people were let to go and work without COVID-19 vaccination certificates. They would be spreading this disease and causing massive deaths to various people. Taking into consideration, my lord, that our country is in a current state, that any other additions may cause the crumbling of our people. My lord, in this regard, I pray that the Constitutional Court finds this in relation to my submission, find this petition frivolous, whimsical, puerile, and dismiss it with causes as regard to the government. I rest my case.
Either you choose one person, the public. Not choosing 2 people, 2 minutes. Each.
My votes. This court has jurisdiction in our application based on Article 137, which says that a person who alleges that any law, authority, or guideline is in contravention may petition the Constitutional Court for redress or for a declaration to that effect. And I would like to invite this honorable court to be considered by the person Joyce Nakajwa versus Attorney General for constitutional petition number 2 of 2001, where the Constitutional Court held that it has jurisdiction to entertain matters that would, in the process of a constitutional interpretation, under Article 137. So, my lords, this court has jurisdiction to entertain our application based on Article 137(3). My lords, the Attorney General submitted on Article 23, which provides for liberty, but specifically Article 23, Clause 1, Paragraph D, which states that which provides for preventing the spread of an infectious disease. And we submit that we are not against the proper measures of abating the virus, but what we are against, but against the creating and adoption of policies that interfere with the enjoyment of people's rights. My lords, the Land Attorney General also asked us whether we are going to represent their bodies. Mr. Attorney General, death can occur anywhere, in prisons where you're throwing your masses, even living out the patients, other patients with other related diseases can also lead to death. So our query or issue is about creating and adopting policies that interfere with the enjoyment of the people's human rights. And it's our humble submission that the new rules or guidelines should be declared null and void, as they are unconstitutional and fail to pass the constitutional test.
My lordship, it's quite unfortunate that the African amnesty outside the trade animal health case, and I'm going to substantiate it. My lordship, in this case, I need to qualify that their justification for the operation is consequential in the subjective sense. For operation, stands unopposed as per the facts. Your lordship, the Attorney does not show cause approxima as why is object to inspection, but rather they validate the facts and quote various thoughts that are bad in nature. Your lordship, I would like to bring this honorable court that the motion is free law as far as for 2. But unfortunately, that's not and this is we believe that the Public Act is more free than the motion itself, and that's an outside. Your lordship, that you can this team go ahead and talk about the security of the matter of COVID. But your lordship, according to what your report, 2014 around the state of Malta, we had over 19,000 deaths because of malaria. But the Attorney General did not move to court of fire to the state of Malta, so make such laws. In the instance case, I move this court find that their submission is malicious injection and that's to be explained from this one. Your lordship, the guy that means by focus period, yet when you human rights case, like bring up calculations, we can justify that it's not supported by anything. Your lordship, they talk about the optics of this court, but they do not find what amounts to the optics court. So they want this court to rule out a function. And therefore, I beg that their submission be explained from this one. Your lordship, the submission from the Attorney General actually taking us in wide space. And I beg that the spirit of constitutionality, the spirit of protecting our constitution, the spirit of protecting the integrity of our court system, this their submission to be expanded for people as soon as possible, so as to save our youth students from such bad laws. Your lordship, the circumstances that this petition is not dismissed. I beg to submit an admonished court of the fact that the independence of our judiciary, especially the independence of this court, is not there to stay. Anytime the president is going around and stepping on justice. Your lordship, in the instance case, I beg only 1 minute to make my prayer. Your lordship, the rights envisaged in our petition are so fundamental that we suspend them to destroy the notion of the civilized state and destroy the best structure of our constitution. I beg to submit.
Raise the ratio. Raise.
Much of that is achieved. I did something that counsel for the petitioner is convoked facts, and I invite God that let's stick to the facts at hand. It is involving facts of malaria which are not attributed to the facts that we have in the matter.
I know she might find that.
Good evening. I have an announcement before we do the deadlines. Yes, I request people to subscribe to the Law Society. The subscription fee is 10,000. People are asking me for water. You want water? Please subscribe to the Law Society. Thank you.
That's judgment. Submissions from both the petitioners and respondents. If you want to give the ruling in jurisdiction, then I shall verify that the final result is this is our the appreciates the line Attorney General submission on the matter of decision in internal courts. Whereas the division has submitted that we have this issue. There is one Article 60 and 137 of the Constitution. Article 50 is specific on when it can be invoked. Not one of those cases. And Article 137 is also specific on when it must be invoked. They are bound by the decision in the case of this military vote, that's the conviction, as quoted by counsel for the religion. And if I want to have a jurisdiction, we are this man. However, please. However, this matter will mean ask for something by law of Moot. This is the Moot, which are overall subsection, and will seek to give the petition the course and interpretation for all purposes of abilities and applying at 126. If you have that, what is addresses, we don't do that for the current. But please note that the matter of petition is not one that shall be treated as a mere impact. Since jurisdiction is a matter of law. Further, apply and state that we reserve our ruling on that. Subject to both parties, finally, you can submission. But in support of the petition, against the petition, and very that, 7 days from. Let's say that was, let's say that in It's 25, 25. May 2021.
So thank you so much for attending. But before you leave, we're going to give some observations. Once presented, and then we shall also calculate 1 month, we find the average, and we shall announce how each of you perform. And then I hope we shall choose the most relevant persons to represent us. Not chosen doesn't mean that you don't know what you do. Discussing, we'll take it here, but you just need to learn more and also train more in the most advocacy, knowing the law, and so on. So let's counsel what is used we are already in mind passing and so on. So you want to
Thank you very much. Right. Submission. I think what there are few issues that I need to air out.
One, present required. He might be the rather list of so Nkumba will not happen. Like that we went Moot, go to America, people give time to the judicial officer, the legislative officer, everything. Give time to the judicial officer, write whatever things. Then on the issue of how to address courts and how to address judicial officer, I think we reached a point that was some people application and the application. Remember, this is about to be breaking. So remember, you submit. Another thing, somewhat for us, etiquette. Yeah, I cannot say before a official. Someone I had spoke because about fertility. And security state. Apart from that, it was a very small. Quite related to facts, and I think I've done some research.
So not so much from as a great presentation from the side, you know, the fact that we are given the facts. But that's very good. The only problem I have, and being an academic, is so most of you that are going to simply know your authorities the way you wish. You are not applying them to practice. Some of you are just submitting orders, but criteria without regard to the law. Someone just put up and started checking us about Maltese. That is going on there. How people are judged. We represent something. Someone research. The one who should this understand that this is a court of law. It's better you submit and you submit from the law and apply the law to serve. Otherwise, going to go down back. Thank you.
One more thing, like you cancel.
For me, I want to talk about the issue of training. So we are going to see who persuaded us more in the delivery of our results and decisions. But of course, most of you persuaded us, and I was also shocked to also want that some people who might be expect to speak publicly, but they are spoken and they are always, which is so good. Then, of course, as he has said, you need to relate the law to the facts. First of all, knowing the law and also knowing the facts which you have. In case of different facts, you don't need to avoid any other facts. What will be the facts? Don't engineer facts, but this is the more competition. We're going to place staff teams, they already know the law, they know the facts. there if there's seeing their thinking by the panel judges, because we don't know the law, and then they ask the question globally, and you panelists or you the participants are not made no afraid. And they see them thinking then that is not good because marks are what they want, coordination and participation as a team, okay, because you have a team, the way they are people or people, you need to work together. If they ask a question to one of the opponents and she or he doesn't know what the law is and the law is stand up, she sits down and then address all what she has been asked, unless it is specific to her or him. Okay, so you need to always cooperate. Again, you did put so much research in the World Organization, the World Health Rules, international health regulations, which govern pandemics. They can ask someone what's the pandemic, and approach they have Googled already and do the definition of what amounts to pandemic. When can the World Health Organization declare this is a pandemic which deserves international attention? Not all pandemics deserve international attention, but what does the World Health Organization consider? Then, Omodek was giving us scientific figures and also scientific statements, but